Good evening and welcome to another episode of Law and Order. On our previous episode, we discussed about the employer, the employee, what is labour law, how does the labour law apply in Sri Lanka, and to what extent can this be taken. Well, to discuss more about the topic labour law, I have with me a very senior lawyer who's been in practice for many, many years. He is Mr. Tilina Panditaratna, a senior attorney at law, joining us today on Law and Order. Good evening.
Good evening to you.
Mr. Tilina, we discussed last time about the employer, the employee, what are the things that you need to, can be taken up in court and all that. But I like to start things off in today's program. When you employ somebody, is there a minimum wage that comes in, or a minimum salary, or can a person say, okay, this is how much I'm going to pay you for this? If you want, you work or you don't work, or can I get a service from a person for a sum that I think is okay? Is there a minimum wage?
Yes, certainly there is a minimum wage. There is something called Wages Board Ordinance, which gives the most of the employment categories, they fall into this Wages Board Ordinance. And in Sri Lanka, present day situation, no one can be paid less than 13,500
as a monthly salary.
Yeah. The 13,000 monthly salary, the minimum wage, there is a depiction called minimum wages, but you can pay any amount above that, but to pay you must pay the minimum wages. So, likewise now for instance, earlier it was 10,000 rupees minimum wage, then the government through budgetary relief 1,000 added, then subsequently recently 2,500 added, that means 10,000 plus another 3,500. So, now 13,500, but that also now increased to minimum of 16,000 with the other things.
So, that's talking about a monthly wage. Now, what happens, like say there are people who have daily wages coming in. Is there any?
There is minimum wages also pertaining to the day's work. Now, for instance, tea plucker. Now, the government recently increased the salary daily wage as 1,000 rupees, where the employer finds it difficult to pay that 1,000 rupees also, but they pay something with all the additions, they try to pay 1,000 rupees. And also it depends on the, if it is a casual employment, but there is a wage, permanent wage, minimum wage I mean. Minimum wage divided by the number of days, and you can calculate the daily wage also.
Yeah, that's very interesting. So, on the part of the things that if we missed out on our previous episode that you mentioned, you want to elaborate a little bit more on that?
Yeah. Now I earlier on the other day I mentioned about the termination.
Yeah.
Where to go, where to claim relief. I said you must file action. File action in the sense you have to just fill a form. That is under section 31B of the Industrial Dispute Act, there is a form. In the form you have to say the name of the employee and the respondent who is responsible for it, and the commencement of employment, salary, designation and termination. Those 4 things must be included in that. And from the day of dismissal, I mean when you mention a date on such and such a day I was terminated, 6 months before lapsing you have to file a case. The 6 months duration is there. So, if you exceed 6 months, your application will be thrown out, not accepted.
Not accepted. So, I think you need to make sure that you manage to work within the period of 6 months to
right.
to file a case. Is
file
this?
a case, yes.
Yeah, but then before filing the case, is there any procedure that goes through between the two parties?
Yes, sometimes
in terms of legal.
Yeah. Sometimes worker, if an employee gets terminated, he is helpless. So, either he will go to the Department of Labour, makes a complaint, then the Labour Department calls both parties and try to see the possibility of a settlement. If they fail to settle the matter, then only they will advise go before file a application at the Labour Tribunal.
So, this solution or whatever that comes in before going into court, if it's disagreeable by one party, then that can be taken into court, is it?
Yes, that's
Can the employee also take it into court?
no, not employer,
Yeah.
employee,
Can
he
take-
has to go.
Yeah, if he's not satisfied.
Yes.
Right. So I think, so the next thing that I would like to ask, when you take it to court, Mr. Tilna, like say you're taking it, how long does these cases take to come in? Because we know that in Sri Lanka it takes a fair amount of time to really come into a final verdict or something.
Yeah, but at the outset, when you file a case, I mean the laborer or an employee files an application before the labor tribunal, first they will ask the employer to file an answer, followed by replication by the applicant. Thereafter, it will be the case will be called in open court. On the very first day, learned president or the judge of the court will not hear the case, but he is trying to see the possibility of settling the matter. Judge will inquire from the parties to conclude this matter without going for trial and number of dragging on the cases. He will ask from the employee, what do you want from the court? Then he will put the same thing to the employer, he will also say. And finally, if the parties are, the employer is not willing to employ him again, then he will say, I want this much of money, so loss for the loss of career. Then the employee will be asked to see the possibility of meeting that amount. Then they will discuss, and if they stand, the learned president always stands in between the suggestions and try to settle the matter. That is the easy way to conclude, and most of the judges they try to do that. That is a very good way, because shortcut. But at the same time, certain employees fight for prestige. The word comes prestige, plays an important, because some employees also think that I will teach him a lesson. Likewise, that type of attitude is also there with some employees, and also employers sometimes, whatever the course, I will spend any amount of money, but I will not employ him again. That type of attitude is also there. So, it is the learned president who will neutralize that type of thing and try to settle the parties. Otherwise, if there is no alternative, if the parties are not agreeable, case has to go on for inquiry.
Well, I think that explains how things. So when you take it beyond that point, if you're not satisfied with the original decision, then it starts hearing the case, is it?
Yeah, that's right. Then hearing the case. Then the first, usually in every court, it is the prosecution or the complainant or the plaintiff has to start the case.
So this happens in the labor tribunal, is it?
Labor tribunal. Yeah. The same procedure applies, but there is an exceptional circumstances. For instance, if an employee does something wrong or misconduct, over that employee decides to terminate his services. So, he issues the letter of dismissal, saying that because of this reason I terminate your services. In that case, if such a situation arises, the complainant or the applicant need not start the case. That is the normal practice in every court. It is the complainant or the plaintiff has to start, but in labor tribunals
it goes the other way.
It is if the employer admits termination, then he has to prove why he
did that.
He has to justify termination on that. So, he has to start.
There is another very important topic that I want to bring up, Mr. Tilna, is that there are a lot of instances we see that there are instances where employees are being sacked from office or being terminated from work due to sexual harassment.
Yeah.
So how does this work? Where can a person who is actually harassed go to? Can that also be taken into the labor court or the labor tribunal, as you mentioned?
Yes, actually there are sexual harassments called, and sexual harassment, there is a criminal procedure, the penal code also says.
Yeah, that's what I because it comes under the criminal act as well,
yes,
no?
yes,
Yeah.
that's
So,
right.
but how does it apply to the
Yeah,
labor matter?
that through that you can apply the penal code and get the dispute. And also it's a kind of bribery also, bribery act. If a lady comes and plead for leave, employer says something, he wants some connection with the lady and say, no, I am not going to give you leave. That is indirectly, innuendo, or indirectly you ask for something else. Keep it. That's called, that's also the kind of harassment, because the legal right, if she is entitled for leave, she must be given after listening to the reasons. But if the employer, not the employer, the person who is in charge there, or the executive or the manager, whoever it is, try to harass her, then it will amount to harassment. And also sometimes ladies use this as a weapon for them. They won't work, but they try to fabricate stories against his own boss.
Yeah.
There are instances like that. That is the creating various stories against your boss.
Gossiping.
And gossiping. Likewise.
Yeah. So, I think that's also very interesting. So, but then those can't be taken into labor court, is it?
No, can. Because if she is not given the leave and not for instance, she will be harassed. She can't have a peaceful mind of work. She can't work there in a peaceful way. So that means then she is a little bit reluctant to come for work.
Because
because of this situation, and she gradually reduces the number of days coming for work. Then employer issues the letter, you have vacated employment. Then she can come to courts and say, I was harassed, sexually harassed because of these reasons. I didn't want to work under him, therefore I kept away.
In terms of proving that, how can the employee prove that?
Yeah, that is also the most important thing. The circumstances, one who listens must believe what she says is correct or true. And she has not only, when if there is such a thing happens, she can complain to any other person, I mean the higher ups, send a letter that I face such a situation, please take steps to relieve me. Likewise, various steps that she also can. She can't just keep quiet, because if she is harassed, she has another person to report, one above him.
I think that's very interesting. And also you did mention about the gossiping part. So that part also can come in.
Yes, yes.
Because you can have made up stories.
Yeah, made up also.
So coming into the next topic that I would want to find out is obviously EPF and ETF for an employee. How does, for example, we know that a lot of basically the private institutions, sometimes they don't pay EPF and they don't do ETF. How can an employee act on this matter?
Yeah. Actually, all type of employees, EPF Act covers, there is something called covered employment, but almost all employments are covered by the Act, EPF, whether it is casual or temporary or fixed term contract, whatever the means, either you pay by the piece rate sometimes, depends on the timing also you pay salary, whatever the even commissions are paid, that comes under EPF Act. The employer has to contribute EPF. I mean, you deduct 8% from the salary of the employee, and the employer has to add 12%, and 20% has to be remitted to the central bank through EPF. There is a form called C return. Through the C return you have. But in the case of ETF, there is no contribution by the employee worker. Employer has to pay 3% of the salary to the ETF directly, Employers Trust Fund.
Yeah.
And also I would like to add to that, it is called superannuation benefits, and also if a worker works for a longer period, I mean the lengthy period of service, if he works for more than 5 years, he is entitled for something called at the end of the employment gratuity. Gratuity usually is entitlement is he must work minimum of 5 years continuously, uninterrupted services, 5 years. Then after 5 years, the last drawn salary divided by 2, half month salary, that is half salary into number of years. That is how you calculate the EPF. Gratuity, sorry, gratuity. But at the same time, there is a law pertaining to that also. Gratuity Act says that applies to places where more than 50, where employees are 15 or more employees. In such a case, the worker has to go to labour courts to claim gratuity.
So again, it's back to the labour tribunal.
Labour tribunal.
Right. So even now, for example, when you are not being paid ETF and EPF, what is the procedure that a worker can take? How does he start the entire thing?
Yeah.
Like and can he do it while he is working as well? Like, so for example, I'm still employed with this, but I'm not been getting EPF and ETF. It's not been deducted from my salary. So the employee is not acting in the correct manner. So how can I take this matter up?
Yeah, you just send a letter to the Commissioner of Labour saying that I am not paid, or else there are various other means to say that you inform the Commissioner of Labour over the telephone. The Commissioner of Labour will send a labour officer, because now the Labour Department, they divide the areas of the city into various locations. So the labour officers are designated for that particular area. So he has to visit all the places where the employment generated and inspect them. He has the right to inspect all the books, I mean the salary books, attendance books, whether they are paid the OT, overtime, everything can be inquired. And when an employee sent a petition or a letter to the Commissioner of Labour, he called both parties, and the employer will be asked to bring all the attendance registers, salary books for inquiry. So when he detect that he has not been paid EPF, the employer has to.
Right. So for example, if I'm the worker and I'm not pleased with it, I'm not happy with it, what do I do next?
Then once you get the Labour Tribunal, the President deliver the order, we will say dismissing the case of the worker, employee. He has a remedy. He can go to High Court of the province, the provincial High Court. He can make an appeal to them, but that has to be done within 30 days of that order. 30 days means except poor days and public holidays, Sundays and public holidays. 30 days is counted in that way. You have to file an appeal at the provincial High Court. And at the same time, if the employer is not satisfied with the order, now for instance, Labour Tribunal President orders 3 years salary as compensation. So the employee is not happy with that. So he also can appeal to the High Court. But in such a case, employer has to deposit that money, what is ordered at the Labour Tribunal as security. And with that certificate only he has to file an appeal at the High Court.
So even the employee has the ability to appeal, challenge the verdict that has been given. So you said within a period of 1 month you need to file
30 days.
Within 30 days. So when it comes, so is it reheard? How do you get about it?
It's only
from
on
that point?
Actually the appeal, in the appeal no evidence is recorded. It is only on a question of law you can appeal. Otherwise it will be a big process. If the High Court is also going to hear the evidence, another lengthy period will take. So likewise, one can appeal against the Labour Tribunal order only on a question of law. So even we will say that High Court gives the order. Now if the President of the Labour Tribunal say that you pay this much of money, right? that against that also you can appeal to the Supreme Court. That's the final authority.
Final authority. So I was going to come to that. Like say, if you're not happy with the appeal also, can you take it again? And how long a period does that need?
Actually, the law says within 6 months or 2 years, but it's practically impossible. For instance, now in the High Court is meant for mostly criminal work. The people who kill people, murder, rape, and all those cases are heard at the High Court. They are accused are in remand. But when we file an appeal, in spite of those cases also, he has to take our cases. But always, mostly, they give preference to criminal matters, because the people are in the remand prison. So likewise, and the witnesses get lost in those cases. Then it's put very useless to have a trial without the witnesses. So they give preference to criminal matters.
So the final outcome is coming at the Supreme Court. So you need to be satisfied with whatever you get from the Supreme Court, because there's no way that you can take it beyond that.
Yes.
Now, my question is like, now say if I'm unemployed or I'm being terminated for a certain period, and this case goes on for about 1 or 2 years, or maybe 3 years, and then the verdict is given in favor of me, say the worker. So the employee obviously does the employee need to pay that person for the time that he was unemployed as well?
Yes, actually, in the labor courts, when the labor tribunal president or the judge delivers the order, he always think about the period of unemployment, and also future, that's called the legitimate expectation. That's how long he could have worked if not terminated. Now, for instance, if a person retiring age 55, he is terminated at the age of 54, he had only 1 year more to work. So that will be counted 1 year, and also if the case drags on for 3 or 4 years, that will also be taken into consideration. But that does not mean he has to order payment for the whole amount, but that time period will also be taken into consideration.
I think we have discussed a lot of things, very important facts of on what, but just another thing that I would want you to tell was, well, in terms of the labor law in Sri Lanka, how powerful is this in terms of supporting the workers?
Because now, for instance, statutory dues. You are asking me about the EPF, ETF. But now, if the commissioner determines EPF not paid, employer will be asked to deposit that money. If the employer fails to pay that, Commissioner of Labour files action at the magistrate courts. Magistrate powers are limited. Magistrate can't inquire into that. That's a certificate called under section 38 of the EPF Act. You file a certificate at the magistrate court. So magistrate, learned magistrate will ask, are you paying or not? If he says paying, he can pay in installments, give him time. Otherwise, he will imprison also. There's a thing called that. And there is no defense available. Very rare defenses are available with the certificate. You can't challenge the certificate. Only on exceptional grounds that you can appeal. Yes.
I think that's something very new to us, and I hope we gave you a lot of details about labor law and how an employer and employee should act in terms of termination and all those things. So let me thank Mr. Tilnavandala for a very in detail description about labor law. Thank you very much for joining us on Law and Order.
Yeah, thank you.
Well, with that, we come to the conclusion of another episode of Law and Order, and the topic today was labor law. Hope you had gained a lot of information on how the labor law acts in Sri Lanka. So till we meet again with another episode of Law and Order, it's good night.